The main part of the case is over. Nigeria won. And what I want to talk about today is, for those who are not familiar with the case, it was quite a prominent issue in Nigeria itself and observed in other parts of Africa. But I want to give a quick potted history of what the case involved and what actually happened, and then just end by some lessons learned and how ultimately it was a good news story for the country. So the case goes back 15 years, where in 2010 the government was looking to procure an agreement to deal with gas supply and processing. So there was an issue with domestic power shortages, and the government was looking at resolving that. And so there was a procurement process, and the government ended up signing a 20-year agreement with this company, PNID, which was a BVI company with no assets, no track record, and essentially a two-man band. And this agreement was entered into but never performed. So the reason the agreement was entered into, there was a number of issues around bribery and bypassing the regular procedures, which meant that the normal procurement processes, the normal due diligence and the normal safeguards weren't complied with. What then happened is that the government was not in a position to perform this agreement. It was basically a scam, and within a couple of years started an arbitration. I think if we move to the next slide, we'll have the chronology. The arbitration lasted 5 years and ended with an award being made against the Nigerian government in the amount of $6 billion, which represented 20 years worth of profits in this agreement. Now, following that outcome, PNID began the process of enforcing that award against Nigeria's assets in the UK and the US. And at that point, Nigeria approached my firm and we got involved. So it looked like a pretty adverse situation for the country. And what we then did was we took a number of steps. The first was to open a challenge to the award on the basis that it had been procured by fraud. By then, the Nigerian government, we are now several administrations down the line, new government has come in and has opened a criminal investigation into what had happened. Why did this agreement, why was this agreement entered into? Why are we in this situation? And that investigation, coupled with our investigation, where we went around the world, we obtained a number of court orders against banks, against other parties. We investigated a vast web of financial transactions, and we discovered that there had been bribes paid at each stage of this process, which had led to this outcome. So the key thing from a legal perspective was that when you have an arbitration award, you have 28 days to challenge it. It's a very stringent process, more so than the court process. Arbitral awards are designed to be final, and it's very difficult to reopen them. We were 3 years outside the time limit, and the first step was to try and persuade the court to extend the time to allow us to bring this challenge. And that had never been done before. 3 years is an extreme outlier in terms of the amount of time taken to bring a challenge. We did that in 2020. We made this application and we were successful. It was the first time in English legal history that a party had managed to obtain an extension of time of this length. This then opened the way to a full-blown trial to challenge the award, which took another 2 years. And in 2023, in October 2023, Nigeria obtained a landmark judgment setting aside what then amounted to, with interest, an $11 billion award. So Nigeria was successful in overturning that award, and on top of that was awarded its legal costs of doing so. We are still in the process of recovering those costs, so the process is still underway, but the main event, which is removing this huge liability, which amounted to 1/3 of the country's foreign reserves, multiple times its education, security, and health budgets, was a positive outcome at the end of a long road where this liability had a huge impact on the macroeconomic aspect of things in terms of the country's exchange rates, its the rate at which it could borrow, a number of other things. So finally, I just want to come on to the last slide, lessons learned. There is a huge amount of learning and insight from this case, and that I've really given a very much the tip of the iceberg in terms of what occurred. But I think if there is anything to take away from this, I would say 3 things. The first is Nigeria has and did have a sophisticated system of anti-money laundering laws, anti-corruption laws, but that doesn't stop a few bad eggs from exploiting or being exploited and manipulating the system. So what happened in this case was that bribes were made in cash, offshore accounts were used, and there were thinly disguised gifts that were exchanged, so arguably customary gifts. And this is where the problems began. So the first lesson is to stringently enforce your money laundering and anti-corruption laws. The second lesson is the procurement process. It is essential to rigorously follow that process. In this case, there is a whole architecture, a whole infrastructure of public bodies and technical committees and a number of organisations which are designed to test and to vet public procurement. But regardless of that, there were ways in which the certain individuals were able to bypass that and to rubber stamp and approve a contractor who was clearly unsuitable. So things like looking at financing arrangements, looking at due diligence thoroughly, looking at track record, ensuring that internal procedures are followed, and that everything from the lowest levels up to ministerial level, that there is a stringent process in place. That is essential. And finally, the legal contract itself. This contract, which led to an $11 billion liability, was 10 pages long. It didn't have any termination provisions in favour of the government. It didn't have any checks or balances. It was a very one-sided agreement. And nobody with, there was a minor government official who signed this thing in exchange for a few $1,000s in bribes. And it basically put the government in a position where it was stuck and had to deal with this liability for 15 years onwards. So it is really important that these agreements are properly drawn up, negotiated, and that advice is obtained, regardless of whether you're dealing with a fraudulent entity or whether you're dealing with a global corporate, a multinational, it is essential that there is a level playing field and equality of arms when you go into these discussions, and that all the usual clauses you would expect to see to protect your position are in place. So I don't want to intrude any more on your time, but I just thought, and I was invited here to impart some insights and lessons learned from this case in the hope that it may prove useful to other countries, as we were told in Nigeria, that it is not just this case created a deterrent for other fraudsters and scam artists, and it wasn't just a landmark precedent in the case of Nigeria, but for the rest of the continent as well. So thank you very much.